Once upon a time, justice depended on witnesses and written affidavits. Now, it can hinge on a WhatsApp chat. Across South Africa and increasingly around the world, digital communications platforms like WhatsApp are being used as evidence in courtrooms. They're exposing misconduct, proving intent, and sometimes reshaping entire careers. We have seen it in the harassment allegations against Eastern Cape Judge President Mbenenge and in the Madlanga Commission's probe into judicial misconduct, real-life cases where messages and screenshots have become key to accountability. But this new digital reality raises tough questions. How do we balance privacy with transparency? And when does truth become surveillance? Can a voice note stand as evidence in court? To unpack this, I'm joined by an expert who understands both the law and the code behind it, Bophelo Seleke, who will help us comb through this. Bophelo, good afternoon. Thank you so much for your time. Really do appreciate it. Admissibility of evidence is an important part of legal procedures. A WhatsApp text, a WhatsApp voice note, to what extent does it meet the current standards of admissibility of evidence in courts and judicial processes?
Good day, Oliver. What we're seeing is WhatsApp is no longer just a messaging app. It's a tool that can shape justice. As you've correctly said, every screenshot or the chat or audio message can influence legal outcomes. So from harassment allegations against public officials to high-profile commissions like the Madlanga Commission, digital communications are rewriting the rules of evidence. And correctly as well, as you point out, this shift raises important questions. How do we balance the right to privacy with the public interest in transparency and accountability? But I think what we ought to look at is the admissibility of WhatsApp evidence in South Africa. So, of course, recently, South African courts have readily accepted or increasingly accepted WhatsApp messages as increasing corroborative evidence. And their use, of course, is governed by the law of evidence and the Electronic Communications and Transactions Act. But in order for it to be admissible, digital communications must meet the following criteria. Its authentication must, one, prove that the message is genuinely from the claimed sender, and two, integrity, that ensuring that the message hasn't been altered or tampered with, and lastly, relevance, that the message must directly relate to the matter under investigation. So courts now accept screenshots, chat exports, or forensic copies, demonstrating a significant shift from traditional paper-based evidence.
Let's talk about exactly that authentication process. I can steal your phone and begin to have conversations with your contacts pretending to be you, implicating you in a crime. Yeah. And then they're like, yeah, no, it's your phone number, it's your WhatsApp, therefore it must be you. How does the court adjudicate what could be that potential discrepancy?
So I think going back to the three criteria that I've just highlighted, but also placing a specific focus on the Electronic Communications and Transactions Act, where authentication is important, the integrity of the information that is being obtained is also centrally important, and the relevance of it. So, for example, you would have seen that and I think also in the Commissions Act as well, Section 3, where evidence is dealt with, or how evidence is to be dealt with in commissions of inquiry. So once the commission has subpoenaed a person to give evidence, it's then up to the investigators to ensure that these three criteria are adhered to. So they have to prove authentication with whatever process that they use. So either be a phone number, either be any other method that's at their disposal, and also ensure the integrity and the relevance of what it is exactly that they're looking for.
Let's talk about third-party access to this, right? WhatsApp is an end-to-end encrypted platform, and we're talking about WhatsApp, but it really is any other messaging app. It could be iMessage, it could be Signal, which is perhaps one of the most secure end-to-end encrypted messaging platforms. The idea of end-to-end encryption in its nature is that only the people with access to the devices, that is to say the owner of the devices, must have access to the conversation and the messages. Now, if you take screenshots and send it to a third party, and a third party uses that as corroborative evidence, can the court dismiss that on the basis that the idea around end-to-end encryption is that third parties ought not to have access to those conversations?
Yeah, not entirely. So I think what we're speaking to is twofold. It's Section 14 of the Constitution, which guarantees privacy, while Section 35(5) addresses unconstitutionally obtained evidence. Now, what the courts do when they subpoena evidence, be it electronic or otherwise, they must balance the privacy with public accountability, ensuring that evidence that is obtained unlawfully is excluded if its admission would render the proceedings unfair. So this balance is central to commissions like the Madlanga Commission, where digital evidence must be scrutinized carefully to respect individual rights while promoting transparency. And I think also the question of the POPIA Act also comes in and must find expression. But a bit recently, we would have then heard of the case S versus Murphy. I think it's a 2023 case, which highlighted how South African courts handle digital evidence. And the courts are very cautious as an act of first instance. They exclude unlawfully obtained evidence, but allow admissible digital communications to inform proceedings. So commissions like the Madlanga Commission, they adopt similar principles using WhatsApp chats to corroborate testimonies and establish timelines while respecting constitutional protections.
Yeah, let's talk about the interpretation, because that's a big controversial part of proceedings. As we saw with the inquiry of sexual harassment into the Eastern Cape Judge President, Justice Mbenenge, is that the interpretation of emojis are also a controversial part. WhatsApp and electronic texting has a particular vernacular that I don't think has been entirely codified, and that vernacular can be misinterpreted quite easily. I mean, you can send me an emoji and you can send another person the same emoji, but those emojis could mean two different things because it's context dependent. There's a cultural grammar to the use of emojis that might not translate in all instances. And the courts have battled with this for quite a while. But what seems to be the guiding jurisprudence around the adjudication of, vernaculars of communication that don't necessarily conform to strictly to the rules of language?
Yeah, the courts have adopted what is called purposive interpretation. So what is important then, and we can look at the recent harassment allegations against one judge president of a High Court division, where WhatsApp messages were central in establishing timelines and corroborating claims. But on a broader scale, what the courts then usually do is they adopt what I've referred to as a purposive interpretation, meaning if the central theme or the central message speaks to one thing, any other thing acts as supplementary to what the initial or the primary purpose or intent would be. So an interpretation of an emoji, quite right as you've said, is uncharted waters, it's uncodified terrain. However, purposive interpretation in this instance at a very basic level would have us assume that a message that I'd be sending to you, followed by an emoji of a smiley face, would be that of me, one, acquiescing or agreeing, or even amplifying that which the central message seeks to communicate to the receiver on the other end.
Yeah, and just importantly here is that given that there's a dispute around the purpose of interpretation, the interpretation and therefore subsequently the purpose of interpretation, that I didn't mean this when I sent this, I didn't mean this when I sent this, does it create enough plausible deniability for the court to say, you know what, we're not going to adjudicate on that? It's unclear.
Yeah. So it goes back again to purposive interpretation, where it being a foundational concept in our constitutional and statutory interpretation, we don't rely solely on that which would stand as a form of evidence. It must also be corroborated with other forms of evidence that either the commission or the courts would have gathered to support that which the charge on the table would prefer. So, for instance, if one was to try, and this happened recently with the Judicial Service Commission, which looked at the fitness to hold office of a judge president, that if we are trying to establish a timeline of when these people began to talk, the messages themselves become important in establishing that timeline, but also the corroborative evidence would then follow, in the sense that were there phone calls or were there any other forms of communication that were exchanged in order to feed into the primary evidence that which the commission or any other judicial body would seek to speak into when preferring evidence.
Yeah, Bophelo, thank you so much for your time, your insights. Really do appreciate it. Fantastic interlocutor on this. Bophelo Seleke is a legal expert. We're going to take a break. We continue on the other side of this.